before that, I will give an introduction of the CPC. Uh, CPC is a procedural law. There are two types of laws in India. One is of substantive laws and another is a procedural law. Now, CPC, Code of Civil Procedure, is a procedural law. It gives procedures how to file a suit, how to defend a suit, what procedures are required to be adopted while filing or defending the suit. Now, another aspect, if a person's rights, any right, have been infringed by any course or any act of any person, then he can file a civil suit. Example, if I am traveling and I met with an accident, for compensation purpose, if I am filing a suit, and for that reason also I have to file a suit, it is infringement of my right, and for that reason I am getting compensation. That is an example for filing a suit. Now, under what category we can file a suit? Under Specific Relief Act, under Transfer of Property Act, under Contract Act, and you can file a suit for injunction, summary suit for recovery of money, a suit for adverse possession, suit against the government or by the government. Now, the person who is filing a suit is called a plaintiff, and person who defending the suit is called defendant. Now, if if we want to read the Code of Civil Procedure, we cannot read the sections itself, or we cannot. If we are reading the orders, we cannot understand the Code of Civil Procedure. To understand the Code of Civil Procedure in a better way, we have to read sections and orders in jointly. Now, how many sections are there? There are 158 sections in Code of Civil Procedure and 51 orders in CPC. Now, what the sections speaks? It speaks jurisdiction of the court. And what the order speaks, it speaks procedures to be followed for the provisions provided in the section. Now, any person's rights are infringed, he will go to the court, he will file a suit that is called as plaint. And what the material involved in the plaint is there in the CPC. There are various stages in civil trial. First of all, presentation of plaint, preparation of the plaint, who should be the parties to the plaint, who should be the plaintiff, who should be the defendant, all that is mentioned in the CPC. Now, section 26, read with order 4, is called for institution of the suit. Now, order 1 of the Code of Civil Procedure, it speaks for parties to the suit. Order 2 speaks for nature of the plaint, means frame of the suit. And order 4 is institution of the suit. And thereafter we have to read order 6, pleadings generally. What should be the pleadings in your plaint and what should be the contents in your plaint is mentioned there. Order 7 speaks about plaint. Now we will go again to the order 1. To protect the rights and privileges of the plaintiffs, he is filing the plaint. When there are 2 or more plaintiffs, what should be the procedure to be followed? And when there are 2 or more defendants, what should be the procedure to be followed? It's also given in the order 1, rule 1, 2, 3. Now, there are sections 9 to 14 is a chapter suits in general. If we read section 9 to 14 along with order 1 to 4, we'll come to know what procedure to be followed while institution of the suit. and what is to be incorporated in the plaint. Section 9 speaks for courts to try all civil suits unless barred. Now there are certain acts which provide certain courts where to be filed, suit to be filed where. Now, just of I have given example of motor accident. There are specific courts are constituted for motor accident claim tribunal. Where to file a suit in the there only. If we want to file a suit under Contract Act, where to file a suit before in Mumbai City Civil Court. And there is jurisdiction, monetary jurisdiction is there, and pecuniary jurisdiction and territorial jurisdiction is there. Now, Section 10 speaks about stay of the suit. If two or more suits file in the same nature, same subject matter, the court is having power to stay the suit. Section 11 speaks about res judicata. When two suits file, one is subsequently filed on the same subject, court is having power to pass an order under res judicata. Now, in the Code of Civil Procedure, the place of suing is also there. Where the suit has been filed, where the suit has to be filed, is mentioned in section 15 to 21. Now, after filing a suit, it is the duty of the plaintiff to get issued the summons from the court. That procedure for issuance of the summons, service of the summons, is given in section 27 and order 5. Now, we have to read section 27 as well as order 5 also. If we read sections along with order, we come to know the procedure easily. Otherwise, not. Now, thereafter, after issuance of the summons, the defendant will appear before the court. He has to give reply. In legal terms, we called it as written statement. It is there in order 8 and order 6. When defendant appears before the court, he has to file his written statement stating all his grievances, all his reply to the contents of the plaint. Now, order 9 onwards, it is order 9, it is speaks about appearance of the parties. When plaintiff appears, what he has to do. When defendant appears, what he has to do. Everything has been mentioned in the appearance of the parties. Order 9. Now, next order is order 10. Examination of the parties by the court. Court has to examine the parties who is appearing before the court. And order 11 is there. Discovery of facts and documents. And order 13, we have to read it along with order 13. Production of documents. Whenever party is appearing before the court, he has to file certain documents about his proof. Whatever proof he is having, he has to produce the documents supporting his contentions. If I am saying that I have met with an accident, I have to produce certain documents showing that I have got injured. And if I am saying that certain person has met with has agreed with me, executed an agreement with me, that agreement he has the certain terms in the agreement he has not followed, complied with, then we have to show the agreement first to the court, and thereafter we have to show that these terms and conditions he has not followed, he has not complied with, and thereafter we have to show certain documents to the court. The defendant is also having a right to call the plaintiff to show certain documents. He can apply under order 11. Thereafter, order 12 is there. This order is interesting one. Under this order 12, the plaintiff can file an application before the court for judgment on the basis of admissions made in the written statement. Order 12 speaks about admissions. If plaintiff is making in certain admissions in the plaint and defendant is also making certain admissions in the plaint, sorry, written statement, the plaintiff can file an application before the court under Order 12, Rule 6 for judgment on the basis of admissions. Now, Order 13, again we come to Order 13, production of documents, impounding of documents, and return of documents. Court is having power to call any parties to produce certain documents before the court. Court is also having power to impound the documents if the documents is found false, incorrect, and void, illegal. And court is also having power to return the documents which are not relevant to the pleadings in the plaint or pleadings in the written statement. Thereafter, Order 14 is there, framing of issues. Court has to frame issues on the basis of contestants in the plaint as well as in the written statement. It is the starting point of the trial. After filing of the plaint, written statement, court is framing issues, and thereafter the trial starts. Court has to frame the issues on the points which the plaint has been filed and on the points which the written statement filed by the defendant. Now thereafter, next stage is examination of the parties in the Code of Civil Procedure. Order 16 onwards, the procedure of examination of parties starts. Court has to issue summons to the witness. Witness has to appear before the court, and it will they will have to examine before the court. Whatever they have to mention before the court, they can mention under this chapter. Next chapter is Order 17. It speaks about adjournments. When the plaintiff can seek adjournments before the court, when the defendant can seek the adjournments before the court, and what procedure is required to be followed for granting adjournment is given in this chapter. Chapter 17 is there. Now, next chapter under CPC is chapter 18, hearing of the suit and examination of witnesses. How to examine the plaintiff, how to examine the defendant, everything has been mentioned in Order 18. Nowadays, we have to file an affidavit on examination in chief. Initially, in earlier days, oral examination were took place. Now, thereafter, after the amendment in CPC, we have to file affidavit before the court stating all the grievances in the plaint as well as written statement. Plaintiff will file examination in chief on the basis of the contents of the plaint, and defendant will file his affidavit on the basis of contentions raised in the written statement. And thereafter, he can examine the plaintiff or defendant can examine their witnesses. On the basis of this affidavit, the other side means if plaintiff is filing his examination chief on affidavit, the defendant will cross-examine as per the provisions of the Indian Evidence Act, and after leading evidence by the defendant, the plaintiff will cross-examine the defendant. Now thereafter, next order is Order 20, is judgment and decree. On the basis of the evidence laid by both the parties, that is plaintiff and defendant, court has to pass judgment and decree. And thereafter, next chapter in the CPC is Order 21, execution of decrees and order. Whenever the court passes an order and decree, final judgment, on the basis of that, the parties to the suit can execute the decree, and how to execute the decree, that mentioned in Order 21. Now, thereafter, Order 21 onwards, some incidental proceedings are there pending the suit. Some incidents happen like death, marriage, insolvency of the parties. If deaths of any parties of the suit happens, what is the procedure to be followed is given in Order 22. And Thereafter, next interesting chapter is Order 37. That is summary procedure. If a party, if the plaintiff is in possession of a check or any negotiable instruments or bills, then he can file a suit under summary procedure under Order 37 of the CPC. In that procedure, in summary procedure, court is having power to pass a judgment immediately without there is no procedure for filing WS. That is written statement by the defendant unless and leave granted by the court. And court is generally not granting the leave unless the defendant deposits the claim amount. Now, next interesting chapter is Order 39. Order 39 speaks about the temporary injunctions, interlocutory orders, and injunction, permanent injunctions. Thereafter, next interesting chapter is under CPC, Order 41. That is appeals from original decree. Whenever any aggrieved party to the suit agrees from the orders, judgments, decrees passed by the court, they can prefer an appeal before the higher court. There are two types of appeal. One is appeal from orders. Whenever court passes orders, the aggrieved party can file appeal from orders. And on the basis of judgment and decree, the parties to the suit can file first appeal. Thereafter, second appeal. Now, next chapter is Order 46. That is the reference. And Order 47 is review. Court is having power to refer the judgment if it requires some corrections, and also review. Court can review the judgment passed by the court by the same court. Now we come to the definition part again. Their important judgment, important definition in the definition part, section 2 is section 2, subsection 2 is decree. We'll read the decree, definition decree. That decree means the formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit and may be either preliminary or final. It shall be deemed to include the rejection of the plaint and the determination of any question within section 144, but shall not include any adjudication from which an appeal lies as an appeal from order, or B, any order or dismissal of for default. There is an explanation. A decree is preliminary when further proceedings have to be taken before the suit can be completely disposed of. It is final when such adjudication completely disposes of the suit. It may be partly preliminary or partly final. Now, from the definition, we come to know that when court expresses its final or formal expression, adjudication of an adjudication, that expression is called as a decree under CPC. It can be a preliminary or it can be a final. Now, next definition, important definition is judgment. That is there in section 2, subsection 9. Judgment means the statement given by the judge of the grounds of a decree or order. Any reasonable statement passed by the court and grounds of a decree is called a judgment. Now, this is the procedure. How can you read CPC easily? How can you understand the CPC easily? These are the procedures followed in the CPC for which we have to uh, file a suit and how we can defend a suit. Now, I am requesting my learned friends, if any query, if we are having, you can ask. We will go through question and answer basis.
Thank you very much, Deepak. I will request if participants has any kind of questions, please ask.
Sorry.
Any of the participant has any kind of question?
Hello.
Yes,
Hello,
please.
Udumbar. Good morning.
Very good morning.
I got a small question. It's for the benefit of all. If there is a remedy in civil and the client also wants to pursue a criminal remedy for the same cause of action, can he do so?
Yes, definitely. The parties, every person is having a right to pursue his own remedy of his own choice. There is a judgment of Supreme Court as well as our High Court. Parties can pursue his own remedy available, any remedy available.
Yes. Thank you. Thank you. Thank you, Deepak. Thank you. Thank you,
Uh,
Udumbar.
Thank you very much, Satendra. Anybody else has any kind of questions?
yeah, Pratmesh here.
Yes, Prathamesh.
Morning. Uh, I have a query for Mr. Deepak. So, suppose I want to file a simple civil recovery suit against a person against the outstanding amount due to me or to my company, but I don't want to file a summary suit. And I want to create some pressure on him so can probably he can repay my money because as you know, sir, civil matters goes for years and years. So is there any
Yes,
provision under CPC wherein I can create some pressure where he can where some probably I can attach his properties or something of that
definitely.
sort?
Definitely. You can file a civil suit for recovery of your money, and pending the suit, you can file an interim application under Order 39 for disclosing his for injunction to restrain him from creating third-party interest in his properties available with him. And as far as another provision is there in the CPC, you can file an application for disclosing his assets. You can file an application seeking direction from the court that to disclose all his assets before the court. He should not part with possession with his assets, and court can attach before the judgment. That application you can also file.
Okay, okay. Thank you, sir. Thank you.
Anybody else has any questions?
I have a small question. Hello.
Yes,
Yes.
please.
Thing is that arbitration is a new trend nowadays. So, in that also, for the procedural part, do we follow the CPC only, or there is a exclusive provision in arbitration?
Yes, Satyendra. There is a procedure granted under the Arbitration Act, but CPC also we can file means follow. Some procedures of the CPC arbitrator has to follow, and like Order 18, Order 6,
Okay.
the arbitrator also this procedure under the CPC.
Okay. Thanks. Thank you, Deepak.
Issues
Thanks.
of documents if required for examination of the parties to the proceedings,
Yes.
CPC required to be followed.
Okay. Thanks a lot. Thanks, Deepak. Thanks. Thanks, Udumbar.
Thank you, Satendra. Anybody else has any questions?
Yeah, I have received one question here. What is the usual tenure of any suit? Like how long the proceedings happens in civil suit? Maybe for the long cause matters or for summary trials. How long is the tenure of legal proceeding? This is a basic question one of the participants has raised. Yeah.
Sorry, pardon, please.
One of the participants has raised a query. What is the tenure of legal proceedings for civil matter and for summary suit? And what is the difference between one is long cause suit matter and the other one is summary matter?
Yes. There is no definition in the code to how much tenure will require, because it depends upon the proceedings only. There is no fixed period of limitation, fixed period of tenure in the court. But nowadays, within 3 years, the normally a suit disposes of. And in normal suit, uh, every procedure is required to be followed given under the CPC. As far as summary procedure is concerned, there are limited procedures there: filing of the plaint, issuance of the summons, appearance of the defendant, and filing of the claim affidavit by the plaintiff, and judgment. If the defendant wants, he can file an application for seeking leave before the court. Court is having power to grant or reject the leave. Court can grant a leave subject to condition to deposit the claim amount by the plaintiff, and subsequently the court can pass a final judgment. And normally summary suits disposes of within 2 years, and normal suits like long cause suits requires more time, minimum 3 years, like that. But there is no guaranteed period under the code.
Thank you, Deepak.
Okay, Deepak, since this is regarding summary suit, so there is a small question like what are the grounds on which the summary suit is allowed to be sent to long cause? So there are some grounds which on the basis of which it is sent to long cause.
Yeah.
So
yes, if the suit has been filed under Order 37 by the plaintiff for recovery of claim on the basis of bills of exchange, the court generally issues summons. The defendant appears before the court. Thereafter, he file an application. The defendant can file an application for seeking leave to defend. And if that application, leave to defend, is allowed by the court, subject to any condition, then it converts into a suit, normal suit, that is long cause suit.
so is this any contentions he can raise, or there are specific contentions mentioned in the act?
The defenses he can raise in the plaint, that only he can raise in the application for leave to defend.
Okay, so if the court is satisfied, then it transfer it to long cause.
When the court is satisfied, then only court can grant leave to defend the suit, and that too, court can pass a conditional order to deposit the claim amount in the court.
Okay, good. Thanks, Deepak. Thanks, Avdumbar. Thanks a lot.
Sir,
Hello.
good morning, sir. Sir, am I audible?
Yes, you're very much audible.
Thank you, sir. So I have a question to Deepak, sir. He talked about reviewing a previous judgment that has been passed by honorable court. My question is, under what circumstances a court goes into reviewing a judgment or a decree or order that has been passed previously by the honorable court?
Pardon, please, Ishan.
So my question is, you talked about reviewing a previous judgment or an order that has been passed by the court. So my question is, under what circumstances the court goes into reviewing a previous order or a judgment that has been passed?
Yeah, definitely. Three contingencies given in the court. It can review its judgment when there is a discrepancy. Whenever there are three types given. Any person, I will tell you the section itself. Any person considering himself aggrieved by a decree or order from which an appeal is allowed, but from which no appeal has been preferred. B. By a decree or order from which no appeal is allowed, or C. A decision on a reference from a court of small service. Now, and who from the discovery of new and important matter or evidence which after the exercise of due diligence was not within his knowledge or could not be produced by him, at the time when the decree was passed or order made, or on account of some mistake or error apparent on the face of record, or for any other sufficient reason desires to obtain a review of a decree passed or order made against him, may apply for a review of judgment to the court which passed the decree or order made the order. Second, a party who is not appealing from a decree or order may apply for a review of judgment, notwithstanding the pending of an appeal by some other party, except where the ground of such appeal is common to the applicant and the appellant, or when being respondent, he can present to the appellate court the case on which he applied for review. As per this provision, whenever if we want to file any document, but we could not file a document before passing of the judgment or decree or order passed by the court. And if we discover that document subsequently passing of the decree, we can file an application for review before the court. That is the uh, under this situation we can file an application for review.
Okay, thank you, sir.
Anybody else has a questions? Okay, so meanwhile, Deepak, let me just ask a few questions which I have. So, why
Yeah.
suit are filed against government, and what is the procedure for that?
If any contract is there, if any person is having contract with a person, sorry, just a minute. If any person is having contract with the government, and that contract, terms of the terms and conditions of that contract breaches by the other party or the government or the person, then in that case, any person, the aggrieved person can file a suit against the government, or the government is having power to file a suit against any person.
Okay. All right. I think Shrutika has some questions. Shrutika, you can ask directly. Shrutika? So, what Shrutika is trying to ask is what comes first, decree or the judgment?
Decree or judgment.
Yes, what comes first?
Decree and judgment, if it comes simultaneously,
Okay.
it goes. Court has to pass a judgment on the basis of decree and decree on the basis of judgment only. It goes together only. There is no rule that which comes first.
Okay. All right. And what are the hierarchies of civil courts?
As far as Mumbai is concerned, in Mumbai there is a small causes court. Will go from down to up.
Right.
As far as Mumbai is concerned, there is a small causes court for civil suit. Thereafter, city civil court, and thereafter high. As far as the district is concerned, there is a judicial magistrate first class, judicial, sorry, civil judge junior division, thereafter civil judge senior division, thereafter it has passed district court, and thereafter high court, and after high court, Supreme Court.
Okay. All right. And then what are the limitation period for filing a suit? What is the limitation period?
That is as per the criteria of the claim.
So if we talk about commercial and property matters, I mean,
If we are seeking a recovery of a particular amount, then there is a limitation of 3 years. Within 3 years, we have to file a suit. If we have to file a suit for immobile properties, then there is a limitation of 4 years given under the Limitation Act.
okay. All right. I think Shrutika has one more question. I'll read it. Whether a preliminary is to be considered as a defense of re-judicate or subsequent suit on same dispute. She has basically messaged this.
Definitely. In any suit, if a preliminary decree has been passed and the other party, the same parties are filing a suit again, then the aspect of res judicata comes. Then res judicata.
Okay. And limitation. I mean, what are the grounds to appear to High Court or Supreme Court?
We can go, there is original side in High Court. We can file a suit directly to the High Court. If
Uh-huh.
the claim amount in the High Court. And for Supreme Court, there is no original side as far as civil suits are concerned.
Okay. All right. I think Amit has some question. He unmuted himself just a couple of seconds back. Amit, you have any question?
Yes, Deepak
Yes,
sir, could
Amit.
you please explain about the pecuniary jurisdiction?
Yes, yes. As far as Mumbai is concerned, there is a initially in earlier days for 10,000 rupees we have to maximum 10,000 rupees we have to file a suit in the small purchase court, and for 50,000 rupees maximum 50,000 rupees we have to file a suit in city civil court, and above the 50,000 rupees we have to file a suit in high court. Now thereafter the limitation of the pecuniary jurisdiction has been increased. Now we can file a suit up to the rupees 1 crore in city civil court, and more than 1 crore we have to file a suit in high court.
And sir, what about the small cause?
Yes, it is up to 50,000.
50,000.
Yes.
Okay, thank you.
Yeah.
Thank you, Amit.
See, just an extension for this question, where the suit lies means whether it is a plaintiff place of business or where the cause of action has arisen or defendant place of business.
Yes, there are there are two three. You can file a suit in two three places. Normally, where the cause of action arises, as far as jurisdiction is concerned, normally we can file a suit where the cause of action arises. Residence of the plaintiff and defendant is immutable.
Okay.
See, what are the situations or matters where the plaintiff place of business for filing suit is preferred or defendant place is preferred? In what kind of matters? And what will be the best convenient mode? Yeah, looking at the territorial limits of court.
Residence of the plaintiff and defendant doesn't matter to the court. The place of
Okay. Sujit, you unmuted yourself sometime back. Do you want to ask any question? Okay. Anybody else who wants to go ahead with any further questions with Deepak?
one more thing I want to add here. There is a
Yes.
chapter itself in the CPC, place of suing, section 50, 15, 16, and 17 of the CPC speaks about the place of suing, where we can file a suit.
Okay.
Hello, is I audible?
Yes, very much, Manisha.
So, as actually I am having one question. If in contract or any agreement, means I want to ask in a business, whenever the party is running any business with kind of agreement with any company, and the jurisdiction clause is mentioned in that agreement, then what is the jurisdiction of the suit, civil suit?
Jurisdiction is always based on the subject matter of the suit.
But sir, if the that jurisdiction clause is mentioned in that particular agreement, then what is the jurisdiction? Means if the in any company is having a agreement, there is one clause that the jurisdiction in place is Bangalore or any other place. Then what? And the cause of action arise in Mumbai. Then what is the jurisdiction, sir?
Then court has to read if he files a suit, if the plaintiff files suit in Mumbai, then court has to go through the contents of entire agreement, where the cause of action arises, where the subject matter of the suit arises, and then court can transfer the suit where the subject matter has been arrived.
Okay, sir. Thank you so much.
Yes.
Thank you, Manisha. Anybody else? We have another last 5 minutes left to go ahead with. Okay.
Deepak sir,
Yes,
it's the last question for me. I just need a little bit knowledge about how the court determine the cause of action.
From the content of the plaint itself, cause of action means when the actual infringement of the plaintiff starts. Example, if I have executed an agreement with some other person for building my hall, for any XYZ reason, if I have executed an agreement with some person, and the other side is infringing that terms and conditions of that agreement, from the day of infringement, cause of action starts. And court has to read that clauses also. And on the basis of that clause, the court comes to the conclusion for the cause of action.
Okay.
Thank you, Amit. Thank you very much. Anyone else wants to add any more questions to the session? All right, so what I'll request the participants, if they have any more questions, please get connected with Genius email ID. All right, and you can always park your questions there. We will make sure that we are addressing all your queries. The email ID is very simple: info@legenius.in. Okay, and I will parallelly would like to inform you that we have the another session also, which will be happening on 11th of November, which will be on the topic of criminal procedure code, which will be leading by Advocate Shadov. Yeah, and I will request participants to please register themselves for for this session. There is a link given in the chat. I will also would like to add that you can also refer our websites, that is Samruddha Bharat Sangh, samruddhabharat.org and www.legenius.in for more information about our NGO and the companies. And if you want to be a speaker in any of these forums, you can always get connected with info@legenius.in. And I will announce now that the session is over. Thank you very much once again to Deepak being here and helping out with the queries which you had. Especially the questionnaire session which we had today was really very interesting, and people their doubts clear here itself only. Thank you very much, Deepak. You all of you have a really very great Sunday. All right. Thank you very much, everybody, and thanks to Samruddha Bharat Sangh and Legenius for organizing this webinar for all of us. Thank you.
Thank you all. Thank you.
Thank you, Deepak sir. Thank you, Odumba.